I happen to be like a very like no frills kind of guy. So if that happens, I apologize ahead of time. But in any event, because it was one was about to come out. Yeah. So that little business that started in my mom's garage ended up being a 22-year business. And it was a little service business that started as me window tinting my buddy's car, and eventually parlayed into a solar company and over the course of many years, and through the ups and downs of the Great Recession and all the nine. All the while, that was the day job that fed the beast that was my insatiable creative side. And so I am a musician, as Professor Kersner said, still identify as a musician at times, jokingly say one day you're never going to hear from me again because I'm just going to go back to playing pub bars in a more simple life. But that day job fed the beast as the musical entrepreneur, if you will. And even in the creative space, if you're serious about what you do, invariably there is a business aspect to it. So along that journey, I spent years playing in indie bands, rock bands, eventually did my own thing, fronted it, still do. But suffice to say, at one point was having a mild bit of success, got approached with a production deal, did not think that I could afford and didn't see the prudence in hiring counsel and entering into this deal. As it turns out, it wasn't exactly the most favorable deal in the world to a starving artist, as you guys probably anecdotally know these stories. And when I actually found out about the hard realities of that, it completely took the wind out of my creative sails. Basically just said, the hell with it, I'm done with music for a while, I'm going to fall back. And eventually got the idea of, maybe I should be a lawyer. Maybe I should be the person who never lets this happen to another kid again, And so as a second life, I ended up going back, ended up at Temple Law, shouts out to Beasley over there, and graduated the night program. I flipped over today. None of that's relevant. But the point is that when I came out, I was entertaining positions at different firms in the mass media market. So your New Yorks, your LAs, your Nashville's, so forth and so on. But I recognized there was an opportunity here in town where all the entertainment attorneys in town were sort of nearing retirement age, or the ones that had like a real strong presence. And they had a lot of love and affection for me, but none of them could really hire me. They didn't have associate positions, but I knew what I wanted. So I ended up just deciding to hell with it. I'm going to hang out a shingle and figure out how this thing gets done, rather than go to another media market where nobody knows me. So that's what I did. I've been a lawyer for about 8-9 years now, something like that. And I've just been grinding it out ever since. So, this business too is just an entrepreneurship, and that's where I'm at. So I ended up going into entertainment law, as was natural. And in recent times, I've switched my focus to integrate significantly in blockchain law and how it actually affects things at the intersection of culture. So I consider myself a culture lawyer, but I work heavily these days at the intersection of entertainment and blockchain. So that's my story.
Okay, great. Fascinating one. All right. Tony, you want to introduce yourself?
Yeah, Ash, awesome introduction. And it's a pleasure to be here with such esteemed company presenting to you all. Welcome, everyone. Really cool to meet you all, and just pop my slides up because I'll go right into it. And I have a tendency to rapid fire, as you'll soon discover. My wife often says that the trick is getting me to shut up. So that might be difficult. But similarly, I went to Temple undergrad, then to Rutgers, then back to Temple for an LLM in tax law, and always with the sort of entrepreneurial spirit that becoming a lawyer would sort of give me the opportunity to do something entrepreneurial no matter where I went, to hang a shingle. So a lot like what Ash was talking about. But I've been a wantrepreneur. I hate that term, but I'll use it to label myself for the majority of my sort of career adolescence, always wanting to do something entrepreneurial as well myself. So I started podcasting in 2018 to try to help develop my book of business as a lawyer while I was working for another firm. Long story there, but podcasting and sort of the inherently entrepreneurial nature of podcasting, building content, trying to develop your own personal brand, which is what all of us basically do as entrepreneurs, kind of led to the inception of an organization called CollegeCast, which I'm the co-founder and chief vision officer of, current finalist of the Changemaker Challenge here at Temple. So gearing up for that presentation a week from Thursday as well. And we'll also be entering the Be Your Own Boss Bowl. So we create podcasts for good, and we help empower student voices through podcasts. And if you want more information about CollegeCast, you can follow us at CollegeCast Pods on Instagram. Go to our website, check out the cool podcasts we're making with nonprofit organizations. Or you can check out my show at selfmadestrategies.com. It's all about entrepreneurship. I interview local entrepreneurs, and I also happen to teach, very fortunately, under the tutelage of Alan, for the IAI. I teach entrepreneurial and innovative thinking. So quick disclaimer for the presentation as a whole. By the way, I will share my slides with Alan, and he is welcome to pass them on to all of you. My email is here, as is my work cell phone number. So if you want to chat, shoot me an email, text me, follow me on Instagram, message me there. No worries. I'm super accessible, happy to answer any questions. But this webinar does not, in fact, provide any legal advice. You can read the rest of the disclaimer here, but use common sense. Contact me or Ash if you have questions about stuff related to the law. Make sure you protect yourself. So for today, for at least my portion of this, we're going to be talking about why you should form an entity and prospectively hire a lawyer, as Ash pointed out. And we'll talk a little bit about the different types of entities, but really, there are sort of two avenues as far as I'm concerned. One is I typically tell most people, especially freelancers, just form an LLC. Even if you're a single, just solopreneur, form an LLC. A single member LLC is totally fine. We'll talk about that a little bit later in this, but protect yourself, be smart. The formalities matter for a lot of reasons, and we'll touch on those as we go. And then we'll talk a little bit about the basics of contract law as well. And so some of the things that you should be watching out for when you're negotiating agreements, I'll give you some pointers and my perspective on how we negotiate agreements at my firm, and how I, for instance, was able to win a negotiation recently for a client of mine that was a franchisee for $83,000. So the tactics that you can use are strategic. They're collaborative. I often say you don't want to go into a very conflict-oriented situation. We'll touch on some of those tips and pointers, and happy to answer anybody's questions if you have more specific ones. Okay, so why should you form a company to begin with, especially if you're just a solopreneur, or if you're kind of trying to develop an idea and you're not quite there yet? Well, first and foremost, it's going to provide you with some sense of formality, just the process of developing one. And I'll talk about what you need to start an entity will help you to be more formal and think of your business more formally automatically. Secondarily, and probably most importantly, it's going to provide you with liability protection so long as you're doing it right. And then last but not least, there are certainly tax benefits, and the sort of separation of your business from your personal assets will help you to make sure that you're doing things right and not inherently slipping and falling on a risky liability banana peel down the line. Okay. I do recommend that you contact an attorney, whether it's me, Ash, or another attorney. What I always say is just make sure that the attorney is speaking your language. There are a lot of bad lawyers out there. There are a lot of bad accountants out there. There are a lot of bad professionals out there. The one tip I can give you to sort of cut to the quick and figure out if you're working with the right person for you is this person making me feel really good after this meeting? That is what their job is, really, right? Is to help you sleep better at night. And if your lawyer isn't doing that, or your accountant isn't doing that, run in the opposite direction and get a different one. So just make sure that they're speaking your language. They know what they're talking about. They sound experienced. They sound like they understand your business and your concerns, and they're not just rushing you out the door unless you're paying them for their time, right? So just look out for that stuff. Okay, so you really should consciously decide early on when you're going through the process of ideation, right? You're figuring out there's this target audience out there. There's this great idea that I have to serve that target audience. But what should I do in terms of the formalities and the entity structure? Again, spoiler alert, most likely an LLC is going to be a good fit for most of you here, but there are some reasons why you might want to use a different entity. And quite frankly, the only way to decide that is to have a conversation with your lawyer, and they can help you make the right decision for yourself. A quick caveat: never allow an accountant to form your business for you. Never, ever do that. Please promise me that if you only take one thing from my speech tonight, it's go to a lawyer for legal services, right? I don't do people's taxes. I do my own taxes, but I don't do them for clients. And accountants shouldn't be doing legal work for clients either. So if the accountant's saying to you, oh, don't, pay that lawyer, it's not worth it, I'll do it for you for $500. Trust me, that's not a good situation. Okay. Usually there's risk that pops up down the line. But if you properly form an LLC, even if you're a single member, you'll have legal protection, AKA limited liability. What it does is it separates all of your business assets and therefore the risks and liabilities associated with that business from your personal assets. That does require that you have some formality, like you need a properly drafted operating agreement, which we'll talk about in a little bit. You need a separate bank account. The business needs to have its own EIN, its own employer identification number, which is basically like the business's social security number. And you need to keep things separate and follow those formalities. Again, a good lawyer and a good accountant will help you to maintain those formalities and make sure that you're doing the right things to maintain your limited liability protection. The other thing is, quite frankly, and maybe you've heard this in some of the other talks that you've been involved in, you can expense things. I'm not saying you should game the system and toe the line that could get you into trouble, but you can certainly expense things that are related to your business. So you can get a lot of tax advantaged purchases under your belt if you're properly structured and doing things the right way. So there are a lot of benefits in that space as well. Then, of course, you're going to have a better ability to raise capital for your business and for your idea with the help of joint venture or friends and family round or something like that, if you have an appropriate structured business. Okay. So an LLC can help with that. But again, your specific scenario may require you to use some other form of entity. This also helps you if you're doing things right, setting up your operating agreement, really having these discussions with your attorney and your other trusted advisors, helps you to set up an appropriate management structure, right? Who's going to do what in the business? And even if it's just you, are you going to hire employees? Are you going to hire subcontractors? How are you going to work out the actual doing of the business? And are you thinking through long-term down the line scalability for your business? So even if you're a lawyer, even if you're a service provider, or even if you're just someone who's like a consultant or does software, you need to be kind of looking at this thing as more than just another job, right? How do I scale it? How do I grow it? And so that all comes with the formalities of setting up a business. So again, you're going to get these slides, and hopefully you can see on my screen here that I've added some comments into each slide with a little bit more detail. This is all very general. Again, it's not legal advice. It doesn't replace having a discussion with an actual attorney, but there's more detail here. So if we don't talk about something really particular, you can go to these slides and kind of look at the information there, okay? But basically, the different types of entities are sole proprietorship, partnership, some form of a corporation, and a limited liability company. The simplest one that still offers you robust liability protection is an LLC. They're taxed as if you were a sole proprietor or a partner, but they offer you the liability protection and benefits of a corporation. A C Corp is almost never going to be the style of entity that anyone at this talk is going to use, okay? An S Corp may be the appropriate entity for you if you have certain tax benefits that you might be getting from forming as an S Corp. But typically an LLC is very straightforward to run, administratively, very clean and very easy to operate, okay? And then there's this other form of a corporation called a B Corp. Now, I kind of personally have a strong opinion about B corporations. B corporations are a certification for another form of corporation where the state says you've been certified as existing for some benefit in addition to just making a profit. Okay, so it's not a nonprofit, but it's a for-profit that kind of exists for an additional cause. Good examples of that and actual temple affiliations are Saxby's and United by Blue, which was created by Temple alum down in Old City. Those are B Corps. The problem is it adds a layer of bureaucracy to your business. My opinion, a little bit strong, but you can go form an LLC and create what's called a triple bottom line entity as well. Triple bottom line entity is an LLC that exists for people, purpose, and profit. 3 Ps. That's the triple bottom line. And you can set that up with the help of your lawyer and create accountability if you want within the business, but you have a lot more flexibility without sort of the rigid, overreaching arm of the state telling you whether or not you're certified as a B Corp. That's just my opinion, but a little bit of added advice for you. Again, why is an LLC really just the most likely entity that's best for you? It's because it offers the same liability protection as a corporation without the additional tax complexity. There are some trade-offs, okay? So it's not all just total sunshine and rainbows in terms of the way that we're going to set up our entity, but you can do a lot with an LLC and still be protected without having to go through the administrative burden of setting up an S Corp. So it's less costly, it requires less formality to administer, and there's less administrative burden. And there's a lot of flexibility in terms of the tax advantages that you can set up if you're bringing on partners or transferring equity to employees or to potential new people that you're merging with. But the disadvantage is you cannot take a salary. Okay, so if you set up an LLC, you can take distributions from the business, but you will pay self-employment tax on the entirety of the profits that you get from this business. So that's sort of one of the things that we talk about with clients of going with an S Corp versus a limited liability company. Typically, these companies are great, though, for freelancers. You see these a lot in the entertainment space, as Ash was alluding to that earlier. You can set up an LLC as a single member, and that's what's called a loan out company. And then you can go deal with your services for others through the vehicle of this LLC, so long as it's appropriately structured. You see it a lot in entertainment. So producers, actors, musicians will create a single member LLC to loan out their services, essentially. There are some considerations, certainly, to setting up an LLC. And those things are that you do need some sense of formality to set it up. You need a properly drafted operating agreement. You need an EIN. And then with those two things, we can go open a separate bank account for your business. Okay. You need to work with a lawyer to make sure that even if you're a single member LLC, you have an appropriately drafted operating agreement to protect yourself in case anyone sues your business. Okay. Now, the necessary information to set up your business, you want to start getting together potential names of the business and just quick legal tips to consider when you're naming your business. Tony's Law Firm is a terrible name for a business. For a law firm, it's not that bad because I'm not going to trademark it or worry about the IP of the name so much, the brand. But and I'm sure Ash will allude to some of this in his talk. But something that's unique or potentially arbitrary will help you to develop a brand that you can later turn into something. Something like College Cast, for example, is better than Tony's Podcasts, right? So working with your lawyer, a good trademark or IP attorney, can help you to choose a name that, while it's not a brand yet, offers you some leverage later on for when you're going to look for that mark to potentially increase the scalability, the streams of revenue, et cetera. Now, how much startup cash will you need to start your business? We all hear bootstrapping, right? It's the sexiest term since sliced bread was invented, and it relates to how we structure our business. But $0, all those TikTok videos you see, start a business or buy a business for $0, is probably not a good response to that question. Usually, if I'm meeting with someone that's starting a business from scratch, I'm asking them all sorts of questions about the stuff that they're going to need to buy to get this business up and running in their first year, including legal fees, right? And we work out a good number that's a baseline. We can bootstrap it once it's running, but we need to be strategic and we need to be very self-aware about the fact that if we have no money starting a business, we really need to take a step back and think about how we're setting this up, right? Now, there are certainly strategic ways to get friends and family to help you get funded, or to get your first round of initial customers to help fund your production, whether that's services, a creative project, or some widget that you're creating. But again, that's a strategic approach, not a literal, oh, I'm just going to start something with $0 and make it work, right? By the way, full transparency, I have done that. When I was an undergrad at Temple, I started a photography business as sort of a side hustle project with air quotes, no money. Now, of course, I had to go buy a camera and all those things. So in truth, it wasn't $0. But it's a bad recipe because we're entering this from a disorganized perspective. Okay. All right. So what types of agreements maybe do you want to have in your business? Well, first of all, regardless of what you're doing, you want some form of a master services agreement or some form of an agreement with your initial clients, right? Protecting yourself. It doesn't have to be anything crazy filled with legalese or jargon. It just needs to ensure that we're building the relationship from a good starting point and we're laying out everything that we should expect from each other in this relationship. That's what agreements and contracts are all about. They're tools to lay out very transparently, hopefully, what we're doing in this relationship. They're all about the relationships. So use them as a tool for negotiating a really good basis for your relationship with your clients, your vendors, or any other stakeholders that you're talking to. It also, quite frankly, makes you look more sophisticated. If you show up with a master services agreement, you're in a better position to negotiate your price, and hopefully you're setting a good market price for yourself, and you can generate more revenue and hopefully scale faster. Okay. The other thing that you might want to consider, maybe you don't need it on day one, but you might want to consider it within your first year, is either an employment or a subcontractor agreement for your prospective workforce, right? Whether that's people that you're going to hire as 1099 subcontractors or W-2 employees. Now, a quick caveat here is make sure you're working with a lawyer who understands the fundamentals of a subcontractor relationship. One, there are certainly IP risks involved in inappropriately drafted or no agreements that are basically no good with subcontractors. Secondarily, there are employment issues. So you want to make sure that if you think you have a 1099 relationship with someone, you very clearly establish those guidelines and confirm that, in fact, in the eyes of the law, it is, in fact, a subcontractor relationship. It doesn't matter what we put in that agreement if the real world relationship is not, in fact, a subcontractor relationship, okay? So it comes down to what is exactly happening in that relationship. Then, of course, maybe vendor agreements, and there are some IP considerations that we may be focused on. One of the things I hear a lot from freelancers or people who are starting a smaller business and kind of working their way up is, do I need an NDA? I will tell you that if you're having discussions with people related to joint ventures, for example, or things like that, a lot of times there are other ways to get around protecting yourself without, in fact, bringing an NDA, a non-disclosure agreement, to the table. So talking with an attorney and working with an attorney that understands that can help you overcome that process. So maybe you don't need an NDA necessarily, but you may have other IP considerations for the agreements that you're working on. Now, post-pandemic, we're recommending that people often consider the potential outcomes. There's only so far that we can go, but we need to look at the flexibility of these agreements, right? Are they flexible? Can we amend them? Can we modify them? Do we need a novation, a new agreement if there's an issue down the line where another pandemic happens or something like that, right? So we look at these agreements, we look at the opportunity as we're having these discussions about our relationship to build this out in a way that we can protect ourselves going forward with some flexibility, right? Okay. We talked about how contracts are related to relationships. That's the key thing I want you to think about when you're thinking about contracts, right? This is all about the relationship. If it's an aggressive tool filled with legalese, it's not going to do justice for you. The other thing is, when contracts are overly simplified, they tend to be fraught with legal risk. So we don't want to sort of over-engineer this thing, but we certainly don't want to oversimplify it either. We got to strike a good balance for your particular situation that says, okay, this is what I do as a consultant or as a creative or whatever. Here are the specific provisions I need to make sure that I'm protected and that this relationship is in the best position to be successful. Okay. We want successful outcomes for all parties to the contract if possible. Now, proposals and scopes of work are typically not binding unless you have some form of a pre-existing contractual relationship with that individual or entity. But we can certainly make those things a part of your contract that can be customized if we're strategically drafting these documents. Okay.
Tony, I'm
Yes.
sorry, just 3-minute warning.
Thank you. I appreciate that because I'll keep talking, like I said. All right. So do you really need a contract? Hell yes. If you ask the question, then you definitely need one, right? So you need contracts with your employees, you need contracts with your prospective customers or clients, and you need contracts with your vendors. They establish expectations. Like I said, it helps us to have the tough conversations now when we're building the relationship and set expectations that we can manage versus later saying, well, I don't like what's happening with this deal, and now I have a conflict with either a client or a vendor or something else, right? That's an ugly situation. Typically, we want a contract that's generally speaking even, meaning it's protecting all of the parties from liability issues and ensuring and establishing what our outcomes are going to be to the best of our ability at that time. So we can establish payment terms. We can talk about what's the legal recourse if this relationship breaks down, right? We can establish frameworks for who's going to do what when, and when do we get to charge more money for our products or services, right? And last, but certainly not least, we can put in provisions that protect us, like trade secret provisions to protect our IP, our proprietary information, okay? Things that you want to watch out for are, again, as I mentioned, if a contract is only a couple pages or it's a one-page agreement, that's probably too simple for any deal. What we mean is it's not covering all of the details to enough detailed degree with respect to your relationship, right? It's leaving a lot of ambiguity open. So that means a lot of risk. There may be some hidden costs, as Ash pointed out. When you're doing a deal, we want to make sure that we understand the clear expectations and exactly who gets paid what for what and how that's calculated, right? Who's going to bear the burden of any costs associated with this deal, for example? We need to look for lack of flexibility. Is this a deal where I'm locked in for 3 years or 5 years? And how can I get out of this deal if it doesn't work out well in a few months, right? And then, of course, we want to look at things like the balance of power and who's setting what goals and accountability and priorities. Just this last bit about negotiations, and then I'll hand it off to Ash so I don't take up too much time. Remember that it's not about you or me. It's about us. It's about the relationship. Try to negotiate the deal from a perspective that adds value to the other person's life, so to speak, because if you wouldn't take the deal that you're offering, why should they? This is an opportunity to collaborate and build return on relationship, ROR, not just ROI, right? So this is a great opportunity for us to have one-on-one contact with another human being and think about how we leave them feeling. If we do things right, this is an opportunity to make them feel great about the relationship that they're about to embark on with us. Okay? Remember that open communication and transparency are way better in the long run because we can talk about potential issues or potential points of friction right now rather than being surprised by it later, which could be a lot more costly as well. And this gives us the opportunity to maybe provide notice and address any cybersecurity issues also that may be out there, right? We can talk about who bears the burden of some of the risks involved in this relationship. All right, I'll stop there. Again, there are a couple more slides, but you can look through these. You can ask me any questions. Thank you all for this opportunity. It was a pleasure. Don't forget to follow us on social media.
Thank you, Tony, and we'll come back after Ash speaks with Q&A. So
I'll be here, yeah.
Yep. Okay, so Ash, let me ping you. And I'm gonna unpin Tony so you don't have to share the screen with him. And you are on.
Okay, wonderful. I'm reminded of my open mic days when somebody goes before you and it's like, well, everybody give it up for Prince and the New Revolution. Next up is Ash. And you're like, I don't want to go after Prince. So
Thank you.
Tony's over here spitting flames. Yeah. So just a couple of points before I jump in. I just wanted to put an exclamation point on a few things that he said. First off, you can tell he's a podcaster because his mic setup is flames. So, got that Rode NT1 or whatever he's got there. The second one is I really want to co-sign the idea that if lawyers get a bad rap, and oftentimes it's not without justification. And the idea that if somebody's speaking over you, that may not be the relationship for you. This idea of being able to relate and them sort of breaking it down on your level and helping and putting you at ease, that's a real good benchmark and bellwether as to whether or not you're in the right place. And the other thing I want to co-sign is because it happens in my practice all the time. I'll get creators and like, hey, can you review this agreement for me? It's one page, no big deal. Like, this could just knock it out or whatever. And like I sort of have this saying, it's not novel to me. There's many iterations of it, but it's not necessarily what's in the contract. You got to worry about what's not in there. And so when you see a short form agreement, you have to be very careful because maybe that's fine enough for just sort of a release in a video or something, whatever. But when you have a more substantial engagement, short is not always the answer because it means it's leaving out a lot of details. So in any event, let's jump in and talk a little bit about IP. I'll share my screen here in just 1 second, just high level. I recognize this is not sort of a legal class, but I think it's helpful to sort of get an overview of IP writ large and sort of the legal basis and how this stuff operates. And we'll burn through some slides and definitely I'm happy to have a conversant thing. If at any point something is confusing or I move too fast or want to just feel free to jump in and just ask me the question. But let me see if I can go ahead and share my screen here. Let's get to this one. Let's see if this works. Okay. Can you guys see this one? We good? Okay, let me see if this, okay, cool. Let me actually pop this down. All right, we all seeing the picture of this handsome man in front of us? Is that we're good? Okay. So as alluded to earlier, IP and entertainment attorney. I jokingly self-deprecate a lot. I joke, I still think I'm a rock star, but in reality, that's my day gig. So let's jump in a little bit. Okay, so at its core, like, what is intellectual property? That term in of itself can confound people. And I really like this little definition I found to it. It refers to creations of the mind that can be legally protected. But that comes in all different forms. And typically, we think of IP having 4 tenets, right? And what are they? And this isn't exhaustive, but these are the main tenets of it. And so copyrights and trademarks, for purposes of probably what a lot of you guys are going to be doing, is sort of on point. And relatedly, patents, if you end up inventing things or have business processes that you want recognized, that's also in there. And then, of course, trade secrets. And so when we talk about the difference between these, we sort of got to differentiate in among them. And oftentimes copyrights and trademarks, I know to sort of non-lawyers, they can be conflated, but essentially copyrights protect works of authorship, original works of authorship. And then we can think of those as books, movies, copy, like if you're doing marketing materials, novels, software code, so forth and so on. It's the written or fixed, as we would say, embodiment of those sort of creative ideas. Whereas trademarks are source identifiers, right? And they're typically logos, symbols, we all know them, words, so forth and so on. Patents, they're the ones that are going to protect inventions and methods and processes. So it's more of a technical aspect to IP. And I'm going to be very honest with you. I'm not a patent attorney, and that vein runs deep. They're extremely smart, and it's a very nuanced area. And so I'll touch on it briefly, but definitely if you end up getting in that realm, patent attorneys are required to meet a heightened threshold. They have to actually pass something called the patent bar. So it's a whole nother layer of knowledge that they'll acquire. And so if you're asking any attorneys about patents, it's my recommendation that you go with a patent attorney specifically. And then trade secrets are exactly that. They're sort of, those are your confidential agreements that are sort of protected under state statutory law, but maybe not federal sort of copyright and trademark protection. But so why is IP important? And IP, when you think about it, you're granted a limited monopoly, and it's for good reason. It's because, like it says here, it plays a critical role in the promotion of innovation and creativity. It incentivizes creators, individuals, and businesses to create these businesses, and it spurs on new ideas, and more specifically, encourages innovation and creativity. Entire economic engines are built around IP, but equally importantly, it actually protects the consumers. So from knockoff goods and distinguishing between Colgate toothpaste and this other toothpaste over here that may not be of a superior quality or an equal quality, so forth and so on. And then, of course, promoting social and cultural development as well. So specifically in the creative and consulting worlds, when we're talking about the creative world, obviously we're oftentimes looking at the copyright protection of works of authorship, like we mentioned earlier, books, paintings, photographs, blogs, so forth and so on. But we also have something called user-generated content. And a lot of people don't know that with the advent of social media and influencer culture, the videos and the content that you are creating there, that too has intellectual property protection in there. And so the ability to leverage and protect those and sort of monopolize that and license it and control its destiny is important. And of course, trademarks are included in there as well. And then in terms of, if you extrapolate a little further, in the consulting realm, what may be a little bit more apropos or sort of adjacent to that is technical know-how, customer lists, and confidential business information. So let's jump in a little bit and talk about copyright. So what is copyright itself? So it's a legal concept that grants creators of original works of authorship a set of 6 exclusive rights regarding the use of those works. And there's a misnomer on how you might acquire copyright. There's a difference between registering a copyright and having a copyright. So in the United States, copyright exists. It's what we call, the word they use is subsists, at the moment that you create something. And it becomes fixed in a tangible medium of expression. So what does all that legal jargon mean? If I sit here with you guys right now and we come up with a melody line for a guitar, for a vocal run, and we do nothing more. Well, ironically enough, this is being recorded. So I was going to say, if we do nothing more, there is no copyright in that because it hasn't been fixed in something. But the fact that this presentation is being recorded, it is now fixed. It's in ROM or RAM copy on a computer hard drive somewhere. And so now that copyright springs automatically out of that. But how do I actually enforce that? Registration is the process of telling the federal government and the public writ large that you are the creator. You're claiming creative copyright and ownership and authorship over this particular piece of work. And it's designed to protect your right as a creator. Allowing you to, sort of go on and license it, so forth and so on. It does include some exceptions. It does give you a monopoly, but there are things I'm sure a lot of you guys have heard about, like it's called fair use, and fair use. We'll get into that in just a little bit later. But essentially, it means that somebody can actually go and use your creations without asking you, and that typically resides along news, cultural, and critical commentary, educational purposes, so forth and so on. And so when you get a copyright, when you create something, right now in the United States at least, typically it's life of the author plus 70 years, or in the event it's created pseudonymously, which means you don't actually disclose who the author is. It's 120 years from the date that it was created. And in the case of work for hires, which we will talk about, which is very important for the economy, or excuse me, the creator and gig economy in the entrepreneurial world, as Tony was alluding to, it's 95 years from the date of creation, which seems like a long time. But if you ask Disney right now, it's not long enough because they're currently trying to fight to preserve Mickey Mouse's copyright to extend it. And at the same time, there have been new bills introduced to reduce the to revert the term of copyright to a renewable 28-year period. So exactly what is required and protectable under copyright? In essence, there's sort of two tenets there. It's got to be original and it has to be fixed. We talked a little bit about fixation, but what is originality? Originality is distinct from novelty, which is a patent concept. Originality just means it has to be original to you. It doesn't have to be new to the world. So theoretically speaking, if you are in, let's say, I don't know, Germany, and you're sitting at your piano, and I'm over here in Philadelphia at my piano, and we just happened to write the exact or near identical melody line, we can both actually file for copyrights on those, and it wouldn't be conflicting, provided like the one has not sort of borrowed or absconded from the other. So you can have independent creation. It's original to both of us. They just happen to sort of be the same, which is an interesting concept. But as some of you guys may have seen in the news lately, there's an immense amount of talk and chatter around artificial intelligence and the effect that that's having on business in general, but the creation, how companies are supplanting freelancers for use of these AI bots and chat bots and sort of programs like DALL-E and Midjourney. And these are things that create artificially through the use of sort of algorithms output. Right now, you have to be very careful using them because it's not at all clear. There's a couple cases moving through the Copyright Office as to whether or not they will actually have copyright protection and what threshold of human input is required. And sorry, I skipped over that. It actually has to have a human element to your creation. So if you do in your travels and in your business come across AI tools and you're using them, you definitely want to have a conversation with somebody like me to sort of get a little bit of a deeper dive on that and how that affects the copyrightability of it, especially if your business is going to be predicated upon licensing that out, or if you are being asked to sign a work for hire and you are in that work for hire, there's typically a warranties and assurances provision that everything in there is original to you and not subject to what we would call any encumbrances. So that's something you want to be on the lookout for. So essentially, what is copyright? There's 6 rights. It's the right to prepare derivative works, to distribute copies, to make copies, to perform the work in the case of, say, a play or a movie or a song, to display it in the case of, say, artwork or statutes. And then there's a related right for digital sound recordings. But what is not protected by copyright? Ideas. I'll get a lot of people that'll come to me, especially in the creative world, say, I had this amazing idea for a television show, and here's what I want to do. How do I protect it? Well, they think you can sort of copyright the idea of it, and that is antithetical to copyright. Ideas are not protected, and as one famous case says, they're as free as the air. Additionally, procedures, processes, and systems, methods of operation, that's all patents, concepts, principles of discovery. Public domain works, those are works that have expired past that life of the author plus 70 years, or that have been donated to the public by the author who has declared, I am disclaiming any rights in this, and they basically call it's Creative Commons, CCO'd. Titles and short phrases, those are not protectable by copyright, but they are protectable by trademarks. And we'll get into that in just a little bit. Facts, right? Can't, facts just simply like, I was born in 1924, not a copyrightable thing, no matter how many times you write it creatively. First sale doctrine, we'll talk about that in a moment. And what they call scenes of fare, or expressions that are common to the subject. And an example of that might be if you're writing a movie about a Western and you write a scene about tumbleweed blowing through and a guy comes out with these guns like this, that's a scenes of fare. It's so common, they don't recognize that you have a monopoly on that. So we talked a little bit about fair use. Basically, if you have copyright in your works, if you are creating content, there are certain uses, and they're listed here, which are excused, and somebody does not need to get your permission for that. There's a misunderstanding in the creative world and the copyright world, generally speaking, about amount and proportionality of something. Like, oh, if I only take 3 seconds of a song and remix it or sample it, that's fair use. It's not, or if I only quote this a little bit amount of this news article or this book or whatever and use it for commercial purposes. That's not true. There is no sort of clear delineation between the amount that you can take and borrow this fair use. It's what we call a multi-factor analysis. There's a number of them. It's, not for this talk, but just suffice to say, there are times when somebody can borrow your stuff without asking and use it if it meets these particular uses here. But something that Tony touched on a little bit, which is really important to the creator and gig economy, particularly if you're providing services, is works for hire. And so this is a situation in which you are the creative genius behind something, but you're doing it on behalf or at the behest of somebody else. And essentially, in the eyes of both the copyright and the world, that person would be the author and the owner of it. And it's under the law. It can only occur and arise in 2 different instances. The first one being where if you're an actual employee of a company, and let's just say you work for Google and you're writing software code in your job, then that work is considered property of Google by the nature of your relationship as an employee, literally an employer-employee relationship. But the other one is a commissioned work, specially commissioned. And that's where most of you guys will run into this, which is this idea that if somebody is asking you to sign over your rights, regardless of your authorship to them, and there's 9 categories that it has to fit in, but they're at the bottom here. But the notable thing about that is it has to be very clear, and it has to be in writing and signed by both parties. So there's a misnomer that just because somebody paid for something, that means they own it. Under black letter law, if there isn't that writing and that very obvious mutual understanding that is signed by both parties, effectively, they have not assigned over those. The other thing, I see we have a question here. I don't know if that's a 3-minute warning. Oh, wow, that went fast. Okay, we're going to move through it. Joint works, that's obviously when you are working with other people. The thing to know about that here is if you are creating, if you have second, third, fourth parties that you guys are putting on there, you, absent an agreement to the contrary, you own both of them. You guys all own it equally, and you cannot assign exclusively those copyrights or sell the copyright without the permission of your co-authors. I see that we're under time, so I'm just going to start moving here pretty quickly, and we'll go through. Derivative works we don't need to touch on. First sale doctrine, the only thing I want to say here is that oftentimes people will mistake the purchase of a physical or digital good for the ownership of rights in that. So a very trite example is if you buy a painting, all you've bought is that physical iteration of the painting. The actual rights to reproduce it, to commercialize it, so forth and so on, that remains with the author. And if that author is not you, then you don't have those rights. Copyright.gov is where you would go to register those copyrights. It's a pretty straightforward process. We can get into more of that later in Q&A if that comes up. Trademarks, essentially, this is the sort of cousin to copyright. This is the right to use an exclusive mark in connection with goods or services. So if you're a photographer and you want to come up with sort of an arbitrary or fanciful moniker to call your business, the availability of trademark allows you to be the sole identifier of that. And the real theoretical underpinnings behind trademark is not so much to protect the brand owner, but it's actually designed to protect the consumer from confusion. So note that it can be a word, a phrase, a symbol, or design, but actually, funny enough, there is color and smell trademarks as well. So we generally limit your trademark to what we call categories of goods and services, or international classes. So that's why you can have Apple computers, Apple vacations, and there's a number of other examples. It's because the computers and the vacations are so distinguishable that they can coexist, and there is no consumer confusion there. There are, again, similarly, there's fair use exceptions to trademarks where somebody can refer to your trademark and not be held liable for that. The quintessential example is if I'm selling Nike shoes on eBay, of course, I need to show the Nike check mark to sell the shoes. So that would be excused under fair use. We can see here, obviously, Temple University has trademarks. Up the top left is their plain text mark, and then down the bottom is their graphic logo. Similarly, the USPTO, United States Patent and Trademark Office, is where you would go to register for your marks. We can skip over these for the moment. Alan, I just wanted to ask, how are we doing on time? Are we nearing? Can you hear me, Alan?
Yeah, a couple more minutes, and then we'll go to questions.
Okay, cool. Thank you. So let me just quick go back up. So steps to identifying and protecting your IP in the business world. So the first thing you need to do is sort of figure out what you have created there. Are we talking trademarks? Are we talking a creative work? Are we talking an invention? So that would be the sort of the first step there, is to understand that. And then we have to determine what is the appropriate legal protection for that intellectual work, and where do we go to do that, right? So in the case of an invention, you would go to the patent office. In the case of a trademark, you'd go to the trademark office. And in the case of copyright, you'd go to the copyright office, of course. And then typically, once you've done that, you would most often engage counsel to assist you with this, because it's not something that average people are adept at, and it can be pretty complicated. But essentially, you would conduct a search to determine if you can in fact protect those. Now, so for instance, if somebody came to me tomorrow and said, I had an excellent idea for a restaurant, it's going to be called McDonald's. We'd obviously know that that's been taken. There's no need to do a search, but there may be other less obvious ones. And so there's a database of uses at each of these offices that practitioners such as myself will go in and search for the availability. And then assuming we feel that it's advisable that you can move forward on it, we'll go ahead and file the appropriate legal documentation. So what does it look like? How much does it cost to register these? So here's a cost comparison of the government fees, and they seem pretty approachable, not too bad. It starts at $250 in the case of a trademark, and in the patent, depending on the size of your business. However, there is more. Once you factor in legal fees, filing fees, administrative costs, and ongoing maintenance fees, it can actually increase quite appreciably. And not to intimidate anybody, but here's an example of, let's just say, sort of average costs to protect IPs, with patents certainly being the most expensive one. These numbers can range wildly depending on how many additional claims or international classes you put on these, but generally starting, through the assistance of counsel, this is sort of what it looks like here. We can skip over risks for a moment, and just at the end here, I want to leave you guys with a few resources that if you needed to look up further, what you could do. So you have copyright.gov, the Patent and Trademark Office. WIPO is the international version of our sort of combination of those first two. The SBA has some really good help with small business people and intellectual property resources. Industry associations are very helpful. Inventors Network, Copyright Alliance, and the Intellectual Property Owners Association. And then, of course, last but not least, everybody's favorite, lawyers. You can always come to help us. So thanks. I know there's a whirlwind deep dive on intellectual property, but I'm happy to answer any other questions.
Okay, great. All right. So great. One of the very unfair things I did to Tony and Ash is ask them to cover about 2 hours worth of material in 20 to 25 minutes each. I think they did a really good job. I'm going to lead with a question and an alternative, and then we'll hand it over to the participants. So a number of times you each mentioned get a lawyer, it's critical to get a lawyer. And I assume that many people in the audience who are starting out freelancing, you know, selling some clothes they design or makeup or artificial nails are saying, are you kidding me? I can't afford a lawyer. So first, I'm going to give you a case history of myself. When I started, and many of you know, I started an international education business about 10 or 11 years ago, the Institute for Global Student Success. I will say I educated myself and was able to do the trademark searches. They're pretty easy on whatever it is you mentioned, Ash, as the website for that. And I think I actually went and registered my own trademark for about $250 a piece. But I guess to Tony and you, Ash, you know, something more complicated like that, many of our audience are just starting. And, you know, the thought and the expense of trying to find a lawyer, I assume, is somewhat intimidating. How should they handle that?
Ash, why don't you go first? I'll let you lead off this time.
Yeah. So let me just say this. As somebody who, prior to being a lawyer, was very much in a price-sensitive world and understands, you know, exactly how prohibitive it can be, I certainly am a fan of. I don't mean to shit on our profession, Tony, but if you don't need a lawyer, I'm not the guy that's like, yeah, it's funny. My law firm, the joke is a law firm for people who don't really like lawyers. That's my tagline there over there. No, but it's a great question, and I'm certainly. Want to make it clear, like, you know, a lawyer is not needed in all instances. There are a number, however, there are times where it is pragmatic. The problem, so like, let's take the trademark thing, for example. I agree. There are independent trademark search firms that you can hire that are non-lawyers that can give you sort of a comprehensive overview of what they find. They will hand you a report. And if you are adept enough at going through that report and sort of making a judgment call and saying, I don't really see anything here, that's great. That's great. One of the dangers, though, with all of this stuff is sometimes the devil's in the details and the nuance. And to the untrained eye, you may miss it, and a lawyer may not. You know, we do it all the time. It's whatever. But the point is the risk you run in that case is that those fees are non-refundable. At least in the case of the trademark office. So if you were to file in 2 or 3 classes and you didn't realize it, you could potentially lose those fees. But if I was advising somebody, I would say, look, there are organizations out there, for instance, Philly VIP, which is an incredible organization for people that may not have the money or the economics to employ them, where they will do pro or low bono counsel. So I would definitely look into situations like that. I would look at, again, third-party search firms, but there's always an element of risk to this stuff. So it's a risk-reward type situation. So pro bono and low bono organizations is where I'd say to turn. I'm not a big fan of like Dr. Google, you know, lawyer Google. You got to be really careful there. You have to be really careful. Tony.
Yeah, thanks. No, I think that was pretty good, and I agree with you. Alan, to be quite frank, there have been people that I have said, you're not ready for this yet. and in the least arrogant way possible. I don't mean that in the sense of arrogance. I mean that, you should be working with a lawyer that is not just looking to gobble up billable hours, right? Kind of piggybacking off of what Ash said. The other thing is, I flat fee a lot of stuff. So, I will have a very transparent conversation with the prospective client and say to them, look, this is how much we charge for X. And, very flat fee. Usually we kind of lump it all in, whatever the fees are to the USPTO, and all that stuff would be flat feed in, with some cap to protect myself, of course, right? Because trademark could get unwieldy. But even in other things, even in contract drafting or whatever, I can say to a client, this is what we charge for this package or this project. This is what we charge for, drafting a master services agreement. And that gives them the opportunity to say, okay, that's how much I need to budget for X, Y, or Z, if they want to work with us. Yeah. And we offer a lot of value add to that. So I would say look for really transparent pricing. There are certainly situations where I'll be honest with a client if it's just too ambiguous. Like I had a client who was in a mess with Oracle. They signed a 3-year software as a service agreement with Oracle, and it was over, this was a bigger client, admittedly, but over $300 and some odd thousand. And when I contacted Oracle opposing counsel and we were trying to negotiate the out of this thing, because Oracle had really shit the bed on this, he said to me, no one ever signs a 3-year deal. So this is going to be a tough deal for Oracle sales to let go of, because they're losing a giant deal off of their books, right? Luckily, we were in a really good position, and I was able to negotiate it very amicably and got a good deal for my client and got them out. But it often can cost you a lot more money to not hire a lawyer and try to clean things up. So in to Alan's point, there are things, look, if you can, when I was an undergrad, admittedly, not that I'm advising DIY legal, but I formed my own entities, right? And I kind of learned by doing. And so is it impossible? No, but you want to make sure that you're doing so strategically, right? You don't want, to Ash's point, you could just be burning through $250 at a time if you're filing the wrong trademark application to save yourself several hundred, maybe, in retrospect. So you got to be smart with your money as well. Often trying to...
Tony, I'm sorry. Can I just...
No, please cut me off. Yeah.
A bunch of people
Sorry.
who have some questions. Okay. So which of you has a question for Tony, Ash, or both? I saw a couple.
I think Merrick has his hand up, it looks like.
All right, go for it, Merrick.
Hey, hi. Can you guys hear me?
Yep.
All right.
Yes, sir.
So I have an S Corp. A couple of years ago, I have it's that do-it-yourself kind of situation. I had I would say a subcontractor, and we did not have the proper contractual arrangement. And he was in New York, and he was working with a subcontract, and they were pretty much hitting me like $2,000 a day for workers' compensation. And is this, in looking back, is this something I could have fixed better if I had the proper subcontractual arrangement with subcontractor, if I didn't try to do it myself?
Yeah, presumably, yes, presumably. Mm-hmm. One of the discussions I always have when somebody comes to me and says, I'm looking to hire subcontractors, it's not, as I mentioned in the presentation, it's not a thing we really choose. It's a definition of a relationship between either contractor and subcontractor or employer-employee. So the first discussion we have when somebody comes to me is, let's determine the relationship first, and then make sure we're in the right playing field, and then structure out the agreement that's appropriate for that scenario. But yes, as sort of a general question, at least for me, and again, if you're working with a good lawyer, trust me, if you hire a charlatan, right? If you hire a crappy lawyer, they're going to take your money, they're going to give you a crappy product, and you could end up in the same scenario. That's just the truth of it, unfortunately. But if you're working with someone who's listening to what you're saying and who's saying, okay, well, tell me about your scenario, and they're really digging into the operational day-to-day and figuring out a solution that works for you, yes, probably you would have been in a better position. Ash, I don't know if you want to add or.
Yeah, I don't have a whole lot more to add other than sort of the way that I'm with Tony. I often, if a client is, I often do my best to accommodate clients financially, if at all possible. And so I will find alternative arrangements other than just sort of, hourly, billable, so forth. But it does have its limitations. But insofar as your prior question or related to here is, it is the sort of ounce of prevention's worth a pound of recovery sort of situation. And oftentimes you spend more money unwinding something than you would have at the outset. And the way I sort of often advise clients is I'm like, look, you have a budget for inventory and machinery and production needs and HR and all this other stuff. Like, you got to sort of consider this part of it another necessary input, right? And it's pragmatic. And you could go without any of the others, but you probably wouldn't. So I would advise maybe don't go out this one as well. There is a fine line, and it is a little bit of tap dancing on the head of a needle, trying to, if people don't have those funds. But I can speak for myself. It sounds like Tony's the same way, that we always certainly try to work with people to get them there.
And
so they
just
don't
real
find
quick,
themselves in that situation.
Alan, I know you're going to cut me off, but just super quick. The good lawyers are typically like that. Quite frankly, insider information. I'm giving you inside baseball here. It's the good lawyers are typically going to be more open to, let's have a conversation. I'm not looking to just squeeze you completely for every dime you have, right? And to Ash's point, they should be a value add to your organization. So sorry. Okay.
Okay, great. Other questions? No? Two brilliant lawyers here and no questions?
I know. This is usually the opportunity to ask those questions, right?
All right. Let me ask another one then. Sid, you brought, I think it was Ash who brought up the McDonald's situation. It was actually, believe it or not, that case actually came up when I lived in Jamaica. There was a restaurant by the name of McDonald's, and it was, and this was, I think, in the 80s, but they weren't selling burger or whatever. They were selling Jamaican food. And I think they actually won against because McDonald's came down there. They were bringing in a lot of McDonald's, Wendy's at that time. And they like, but they actually won the copyright. And to your point, and I think it's because they were kind of different food. They weren't doing burgers and stuff like that. Just want to throw that out there, Ash.
Yeah, so I would imagine, I don't know that specific case, but I can probably surmise what happened there. There's a concept in trademark law called junior users and senior users. And senior users essentially are first in time, first in line. And I suspect what happened there was that particular McDonald's had pre-existed the corporation coming in there. So they had geographical and local prowess and prominence. And so Big Bad McDonald's Corporation couldn't come in and just knock them out. I absolutely, if I was a betting man, would say it's not because one was jerk chicken and the other one was fried chicken with mayo on it. But it was probably because of that junior senior situation. Okay. And trademarks are geographical in nature.
Yeah.
Okay, cool.
Right. Yeah. Okay, Roberto and then Lucia.
Hi, everybody. Thank you, Anthony and Ash. That was a great talk. I appreciate your time. I had a quick question, and I don't want to play devil's advocate here, but I do recall when I first started my startup many years ago, I dealt with a company. She was more like a private service, and I thought she was a lawyer, and I ended up doing a lot of the work to register my company, and this was my first startup, keep in mind. But it's not that she went about as being one, but I realized that there's other hybrid resources out there that provide similar services, at least for the early startup stages for a lot of companies. And I was just wondering, how do you feel about those types of maybe that competition or something.
Ash, go ahead, go first, and then I'll. I'm very opinionated here, so.
Yeah, sure. Look, I don't necessarily care as long as they're not practicing actual law. What I worry about is a vulnerable client who feels like they are actually getting legal advice and the practice of law is occurring, and then that leads them astray and gets them in trouble. When it comes to adjacent services, administrative services, like, look, you can go to LegalZoom or you can go to the company corp in Delaware or whatever, and they do these formations or they have these documents and all this stuff. It's fine. To me, I'm not so much worried about it as long as it's not marketed as reliant, but the problem is there's a fine line there, and there are a lot of charlatans out there who put themselves over. Anecdotally, I'll just say this. I knew of a guy doing music contracts for years that was not a lawyer. And it wasn't until later that I realized he didn't know what he thought he knew once I started to learn myself. And I was like, wow, some of this is dangerous because you're putting these clients over and you're not equipped to do it. That's a different situation. The ones that are just administrative So Tony?
Yeah. I was going to add
go ahead.
The idea is that it helped me for license. There are certain permits that were critical, basic stuff, but when it came to actually structuring my organization, I definitely didn't take that approach with them. But I know what you're saying, because to some extent, it almost felt like you kind of get sucked into doing everything with them, and that could be a red flag.
Yeah, admittedly, at least in my practice, where I see it mostly is with accountants creating entities for clients. And I despise this practice for many reasons. It's not about the filing. The issue is the accountants always open an S corp, always. And I have a conspiracy theory that's they're opening S corps because they can charge more for the tax filings than they would an LLC. Albeit I have been yet to hold an accountant down long enough to get them to admit to it. But that's my conspiracy theory, and I'm sticking to it. So the problem is they form an S corp, right? Typically it's an S corp, but even if they did an LLC, they're not drafting the appropriate agreements, and they're not providing you with the detailed information that says, hey, you just started an S corp. You got to have an annual meeting every year. It's a corporation. You got to do certain formalities to keep it open. And then guess what? You've been operating for 3 to 5 years or more, whatever. You have some liability thing that pops up and you get sued. And now you go, what do I do? And you don't have, and I'll tell you another tidbit of truth. I charge flat fees for entity setups, right? I include the state filing fees and all filing fees. And in all honesty, it's a loss leader for me. I'm not charging anything additional to do the filing, but we do charge appropriately to do the operating agreement and the operational things. And we do a lot of value add for it. But that's the trade-off, right? Is you're paying a little bit more, but hopefully you're getting more value out of working with the right people. But yeah, great question.
Okay, so we have 5 minutes for, is it Lucia or
it's Lucia.
Lucia, I should know this, right? From last year. Okay, so we have 5 minutes for the question and answer, because then I have to give everyone codes for their points. So go for it.
Thanks, and thank you both for all the great info. So I was curious about, I'm working on starting what is now just kind of a blog, but in my mind, it's going to be kind of like Wired magazine or Entrepreneur, But in terms of where I'm at with it kind of being a blog for now and looking to ramp it up and things, are there any particular legal thoughts there?
Yeah, well, first and foremost, I think you really want to get an entity structure in place to protect yourself in terms of liability, because you could have a lot of issues. I'm sure Ash will address the IP issues that could arise. And then the other piece is if you're scaling. So if it's just you, that's one thing. If you're scaling, though, and you're bringing in work for hires to do the, article drafting and the research and stuff like that, you've got massive IP issues down the line. And so you need a combination of IP provisions and protections and strategy. And then a proper either employment or subcontractor agreement for all your people, because you're going to develop, trade secret stuff like your vendor contacts and whatever gets you rolling, right? And then you've got potential work for hire. Again, Ash can touch on that, on the IP stuff. I don't want to step on his toes, but you got a lot of issues there in terms of those connections. And then you want to just start to get really formal, because if it blows up, hopefully for you, then you want to be in a very organized position so you can stay in control and continue to grow. Go ahead, Ash.
Yeah, no, that's a great synopsis. In terms of the IP situation, it's first of understanding your direction. Are you looking to be acquired? Are you looking to stay independent? Would you be assigning over the copyrights into your, prior work product, or is it a prospective, situation with that third party? Really, when I hear blogs and stuff like that, my main concern is like just being mindful of your commentary. And something that we didn't really touch on is sort of defamation, defamatory. I don't know what your topic matter would be, but you have to be careful anytime you're publishing that you're not defaming or saying untruths about people. In terms of the protections there, what makes those particularly interesting and a little bit different than maybe other artworks is the frequency. It's rather impractical to copyright every single blog, because you're doing maybe multiples a day at a time, and oftentimes that whether that commentary is enforceable or actionable is fact specific. So there are some nuances in terms of when and where to register if you're ever going to do it, those copyrights. Now, again, just because you don't register it, and I didn't mention this earlier, doesn't mean you don't have rights in it. The difference is you can't take a claim if somebody were to rip off your blog and use commentary from that. You would actually have to retroactively quick file for those. And there are some nuances about retroactive filing versus preemptive filing. But I think Tony did a great job describing sort of the other considerations there.
Okay, great. So would everyone please, I'm sorry, I didn't mean to cut you off. Would everyone give Ash and Tony a hand for all that free advice and
Thank you.
humor?
Thank you all. It was great being here.
And everything else.
Definitely.
Okay, so a couple things before we leave, and I see that I actually did better this time. I got it up there right away. All right, we went over this. So tomorrow, Be Your Own Boss Bowl. For those of you here know, it's the granddaddy, grandmommy of all competitions. Over $100,000 in cash prizes and in-service prizes. And there's a workshop tomorrow, Marking Opportunity and the Competitive Landscape, 5 o'clock virtual. Scan it, be there. As I mentioned last week, even if you're not entering the Be Your Own Boss Bowl, this is great knowledge to have, and there are great experts speaking. So please do that. Next, March 2nd, next Thursday, be there. It is a social impact summit, including the Changemaker Challenge finals. So we have 5 undergrad finalists, and we have 5 upper track, which are grad students, alums, faculty. So you get to see Tony present next week. His idea, and we have some great other ideas. There will be great desserts from some alums who have created gourmet dessert kitchens and restaurants. So scan that code and be there. We're also going to have a guest speaker. They are as yet unidentified because there's a bidding war who wants to speak with us. But we will finalize that shortly. Okay, next, we're going to skip that. Suitable points for the undergrads, please scan. If you are a graduate student and want what they call the FDLG points or FDLP, whatever, write us an email at iei.com. Help me here, Emily. It's Temple? Help me.
It's iei@temple.edu.
Thank you. Okay, that's Emily Hart. She helps keeps all of us in line. And I think that is it. We hope to see you next Tuesday back here for our last session. Next Thursday at the Social Impact Summit. And if anyone gives a damn about anything going on in their community, their world, it's a great place to be. You'll be inspired by some of the ideas you hear. And also tomorrow, the Be Your Own Boss Bowl workshop. So thank you again. And again, great resources, Tony and Ash, and take advantage of them. And you can always approach all the IEI mentors, IEI, if you need assistance or even direction on any aspect of your startup and what you're doing. So have a good night, and we will see you soon.
Thanks, guys.
Thanks, everyone.
Thank you, guys. Very
Take care now.
informative. Thank you.
Thank you.
Appreciate it.
See you.
Thank you.